hard to be bored. Let's see here. But thank you for the invitation.
Yeah.
Anytime, it's, you're free to stay.
So you are streaming.
Okay, can you hear me?
Uh,
Let's test that. So,
This is his post. I'm trying to see. If
hey, Michael, can you hear us?
I can. Can you hear me?
Yep, absolutely.
Awesome.
We need to change rooms, so.
It's an online Zoom meeting.
It's just a little delayed.
I don't
So it'll look like we're in a kung fu movie.
Well,
I like
so they have one, well,
He was ready to let us have it.
Yes, yeah.
I've already been there. I don't need to. That's not what I was expecting today.
So how long you guys been on the HRB?
December? Yeah, I think it's
November? You both came on just
No, this is my second term.
second.
Yeah, they redid it in November, December, right? Forgot what's the term? November usually?
But
If you're not filling a
But it's, yeah,
It's
the
always-
vacancies is
yeah.
usually what ends up kind of happening more than not. But, you know,
Yeah, he's on planning commission, right?
yeah, I'm also on the planning. So I've seen you in there as well.
Yeah, so you've taken Scott's spot, because Scott used to do both.
That's, actually, I came in, I had a couple meetings with Scott, so I took somebody else's spot. And then Scott moved on shortly after I was there.
Okay.
So I've been kind of following him, but I'm not following him any further. This is the planning commission as far as I go.
I'm right here, so you can sit wherever there's a free chair. And we do one more thing.
Hello.
Hi, I'm Kirsten
Yeah,
Sandberg.
that's Tom. Tom.
Oh,
Yeah,
yes,
I don't
Tom.
think we-
Nice to see you again.
Yeah. We did meet, I think,
One
time
meeting.
before last.
Yeah. Hi.
Okay, fair enough.
So we're gonna use the, glass again for the PowerPoint. Is it?
Yes.
Sure.
Worried about security, because we can monitor the front door from that, but the building's wide open, anyone from the public can walk in.
You know,
So that's why, I was trying to get Linn set up to. So you have the door locked, and then they can contact my cell number, and I can go let them in, so that's. Let's see here. File tree. You know, I've talked recently. Have I answered all your questions? Okay, cool. Okay. Okay. My list of is like this long, so I need to
Actually, I found another one that's gonna put another question into the new code as well.
okay.
But
Well,
that's for another day. That one's a
Okay.
while.
we have a spreadsheet of fixes for the future, so we just keep
Yeah.
so I have things to fix.
I've got a couple of creative projects with the new code, higher density stuff.
Yeah.
And it's putting, like, how do you interpret this?
Yeah.
How do we interpret it?
Yeah. So side yard does apply.
Oh, is that?
It does.
On each unit?
Yes.
Okay. So that answers my
But the
question.
exemptions are this long, so
Yeah, oh, no, I know.
So yeah, that part, but yeah, it does apply. We talked, I guess it involved.
Oh, that's good. I got one. It's kind of falls in that same code area.
Okay,
I can't remember right now, but I wasn't gonna fight you until I heard back on that one.
okay, yep, no, it does apply. So,
Okay.
Yeah.
I've been kind of designing this as assuming that, so that's good.
Okay. Guess we are still waiting for James.
I think somebody's calling in.
Hello.
Hi, is that James?
Yes, it is.
Excellent, welcome from Pittsburgh. So,
Hey, thank you very much.
okay, So I think we're about ready to go. So do you have a copy of the agenda
Oh, my phone.
or does someone here have to do it? I know you're calling in remote, so. Okay.
I could run it really fast too.
Oh, that'd be great.
Yeah.
actually.
We have a quorum. Yeah.
Yep, we have a quorum.
Want to start?
Okay, well, hey, Lynn, are you ready to record? Then we're about ready to start. Oh, is it recording? Oh. I didn't see that. Okay. Cool. We are recording. So yes.
I will call the meeting to order. It is August 15th, 2023 at 6:05. Roll call. Can you do roll call for me?
I can do a roll call. So I think James Manning,
Present?
Michael Fuller.
Present.
So I need to pull up my list of everyone.
Dan Salty here.
Dan Salty.
Kirsten
Kirsten
Silver's
Silver.
here.
Tom White.
Tom Lawton's present.
And I am noting that Danny Schreiber is not here and neither is John Steele. So, okay.
And would any public like to speak? It does not look like there is any public speakers today. So number 3, approval of the draft minutes. I'm going to break this out into 2 approvals since I was not here on July 18th.
Okay.
Would anybody like, we have to make a motion to approve the minutes, correct?
Correct.
Yes, would anybody like to make a motion to approve the July 18th minutes?
I'll make a motion to approve July 18th minutes.
Second. I second.
All right, there's first and second. All in favor, say aye.
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 Any abstain? Any noes? Motion passes. And then I'll move to approve the June 13th minutes.
I'll make a motion.
Second, thank you. Is that Michael? All in favor, say aye.
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 Noes? Any abstentions? Motion passes. And so we are delighted to have a training by our staff city attorney in-house, who's going to be giving us a land use hearing. So I will give the floor.
Great, thank you. So I'm Bill Monahan. Actually, I'm not in-house. I'm contractor
That's right. Sorry
through
about that.
the Jordan Ramus firm. We've been your city attorney since January of 1989.
That's an absence.
So
Yeah, you're effectively.
And I've been with the firm off and on for most of that, well, about half that time. And I've been working with West Linn throughout the time that I've been associated with the firm. But there will be a transition shortly, probably in the next month or so, to an in-house attorney. The council made a decision at the end of last year to seek an in-house attorney. I know the council has been going through the interview process, but I don't know the status of that. We'll probably still be available as outside counsel for other matters. I don't know if that will include land use. It all depends on the capabilities of the person that comes in. But I'm expecting that the new city attorney will try to be a participant at each of the city council as well as the board and committee meetings. So even if that person doesn't have land use background initially, I'm sure they'll have one for a few months. We're always here to help. So John asked me to provide some land use training, and what I used is a document that I've used throughout the years, used it in West Linn a number of times for training on quasi-judicial hearing process. And this time I had added some additional features because I use this many other places across the state, but West Linn, as you would imagine, is different. So I thought that since this is probably the only opportunity that I have to speak to you about the process, I'll try to incorporate West Linn's process.
And is there a notable way that West Linn is different?
Yes, The way that Westland is different is in terms of the rules of procedures. You have rules of procedures that are established by the city council in its council rules. And within your municipal code, section 2.04, subsection 2, there's a reference that says that all boards and committees will follow rules of procedures that are consistent with the council's rules, city charter, municipal code, as well as the state of Oregon. And most communities adopt some rules of procedures. And it'll be how votes are taken, how to deal with conflicts of interest. Sometimes it'll be the order of an agenda, that sort of thing. Westland's is very complex. This document that I have has 28 pages. Typically, they're 4 or 5 pages long. A city council will review them once or twice a year, once every 1 or 2 years. Westlands requires that it be looked at and reviewed by council every 2 years. There was an effort made before Jules left as mayor. There was an effort to look at the rules, but they didn't make it very far because they got really bogged down. They're in the process right now of reviewing those rules. So I want to give you a heads up that what I tell you tonight, watch that process. Yes. And there are likely to be some changes. The ones that are being talked about were addressed a week and a half ago at the city council meeting. And one of the key ones is a requirement that a member of the public who wants to speak and give public comment is allowed 5 minutes under the present rules. And the council was proposing to look at revising that to 3 minutes and some other things such as that. And these rules, oh, you came back. You have phone?
Could it be on the floor or the other?
Is it in the other, is it in the other room?
Might be in Jared's room.
So what I wanted to emphasize on the council rules is councils have the ability to create their own rules. Typically, they do that for the functioning to make sure the public is aware of how to participate and also to maintain decorum. And it gives some rules that the chair can follow. Some communities will use Robert's rules, which I always recommend against because they're for huge organizations and most of us don't know Robert's rules. Frankly, in my capacity as parliamentarian, I'm supposed to know Robert's rules, but I'm more focused on how does the city want to operate. So I'll get into some of those key points that you may or may not encounter. But do we want to use the PowerPoint if you have it?
By all means.
So folks can see what I'm referring to. And I use PowerPoint as a crutch. It's something to refer to make sure I've covered stuff, but I try not to go through them verbatim. And copies of this, I'm more than happy to have them shared with you. It's in a Word format, so you can change it to use in the future. But how I look at this is from the city attorney's chair. I like to talk to boards and committees and give some advice on how to make the meetings work more smoothly so that you're compliant with state law as well as with the city's process. So what I'm going to talk about is some tools that we need to be aware of, the roles that the various participants in the process have, how the hearing requirements are followed, the fact that we're looking for transparency, and I'll get on some best practices. So the things that are tools, we can go to the next one. John, do you in control of that one?
You can control this now. So
I can control it. Great. Okay, that's scary because I always go backwards when I should go forward.
Okay,
So
that way, I think.
Hey, John, can I interrupt real quick?
Of course.
Could you, is there a chance that you could email that PowerPoint out?
Let's see here. To you right now?
Yes, please.
I could probably do that.
do you want to do that while I keep
Okay.
going?
I'll be
Is
right
that
back.
okay if I keep going with that, James?
Yes, no problem. Thank you, Bill.
So the things that apply to the HRB, you've got the comprehensive plan and the development code. There may be some other specific ordinances. We know you do have those. You've got the historic regulations. You've got studies that have been done over the years and might be future studies. There's obviously the staff reports that are very important for each and every application you have. The ORS applies in certain cases, and these rules of procedure that I added to this PowerPoint presentation. And then this tool is that you can have training sessions whenever you feel it's appropriate, particularly when you have new members come on board or there's changes to procedures. And I always emphasize the teamwork aspect of making these things work smoothly. So here's the roles. The HRB acts in a quasi judicial capacity. You also act in a legislative capacity. When you're quasi judicial, you're acting as a body to make a decision that requires that you follow certain procedures. When you're in a legislative process, you're going to be providing advice and input to someone else who's making a decision. Typically, that's the city council, but sometimes it may work through the planning commission. So the chair's role, of course, is to preside over the meetings. That he or she is the person responsible for maintaining the decorum and follows the process towards decision making. And the decision-making process that we have in Oregon is much of it's laid out in the statute that we have to follow. And sometimes the procedures that we follow that are within the script are there for a very specific reason that I'll talk about, and they provide us with some protections if they're done properly. This all starts from the point that the staff goes through the initial analysis of the land use application and deems it complete, and then provides notice of the application and the hearing. That notice is very important too. So we're under some strict state guidelines, but they're beneficial to the city to follow. The roles of members of the committee, of course, that are prepared for the meetings, to make the disclosures that are necessary if there are any conflicts of interest or ex parte contacts of bias to declare, to give full attention at meetings, and to participate as fully as you possibly can in the decision-making process. So here's what staff does. They're the experts on the plan and the code. They're the people that the applicant comes to. Staff's obligation is to provide guidance based on the information provided to them as to how a person can go through the various steps to lead to a decision. And the Oregon land use system is set up so that if a person follows the direction of staff or they follow the code, they should be entitled to a decision that's positive. They should be able to get approval. Now, I heard at a recent council meeting a few months ago, a former member of the city council made a comment to the council that that's not necessarily so. That the council has a different ability. They don't have to follow the same rules as the planning commission. I'm here to tell you that's not accurate. The system is set up so that we should be able to go from point A to point Z, and if a person has met all the criteria, they should be able to get an approval. The staff drafts and presents the staff reports and the recommendations, and then they'll prepare the decision and the recommendation with findings. Most times it's provided in advance in a draft form, but you don't have to adhere to the staff's recommendation of findings. You can enhance your decision, and you may go contrary to the staff by coming up with some other determination. It's important that you developed findings to support your decision, and we'll talk further about findings. The planning staff also processes the appeals. The appeals of the planning commission go to the city council. Your appeals, I believe, go directly to the city council also. Correct. Your recommendations go to the planning commission, but the city council several years ago decided it wanted through the municipal code to call any decision of the HRB and the planning commission directly to them. They don't want them going through another step. And actually, that's a good thing in the sense that we're all operating under the requirement that any land use application that's submitted, once it's deemed complete by the staff, has to be completed through the other end, including local appeals within 120 days. So there really isn't room enough to have the HRB, planning commission, and city council. Each one requires a notice, each one requires a public hearing, each one just, by the way, at any time, please ask me questions, and I'll hope that if there are those virtual hands raised on the screen, or someone just wants to speak out who's participating virtually, we'll hear you and take that into account. Staff, of course, is also a resource during the public hearings, helping to respond to questions, taking any input that you have of what additional information needs to be gathered before a follow-up meeting, and to prepare the findings and the final decision. My role when you have me here, and by the way, I'm not always at the HRB meetings, they're only when the staff says we need you because there's a quasi-judicial hearing or some other reason. And then we're here available to be of assistance. And typically, I'm not available to the members of the public. But if there are questions from the public or members of the board before the meeting, go through John. John will send them to me and we'll try to answer them before the meeting rather than. What are we, this is from, again, from the city attorney's chair, what do HRB members need and expect? Well, I would imagine you're looking for the most full and understandable staff reports you can receive that have all the application information, identification of the criteria that apply to the particular application, and the various options available to you. And the staff needs to be available to explain the code, to also bring to you any input from departments and agencies. And you may have input from the building department. You may have input from the fire district. And the staff will try to gather that information in advance of the hearing. Then, of course, answering questions, providing complete and objective answers. Staff's neutral. Staff's role is to carry out the code, not to impart their own opinion about a particular application, and give guidance when appropriate. And we're always looking to make these hearings as transparent and respectful as we possibly can have them. I've said to many boards and committees when I give training, what I always recommend is that when you get members of the public speaking, to get the temperature of the room to the right place, please make sure that when you're addressing members who want to give input, if they're angry, or if they're happy, if you know them, they're your best friends, or the people you've never seen, or they're from out of time, treat them all the same level of respect. Ask them to all conform to the same limitations. Limitations meaning give us your name and where you reside, so they don't have to give their specific address. We try to keep that clean as soon as we can. But also make sure people come up and speak so we can capture their input into the record, because the only way that they're going to have the ability to appeal a decision later on is if they establish standing. They don't get up and say what their name is and their address and how to make contact. They didn't fill out the information form. Then they may have a problem with something.
We do have forms for speakers, right?
Correct. Yeah, they provide their address and contact information, so we can send notices later on. Yeah.
How do they do it when they participate online?
I believe that's collected when they sign up as well, and also we have their email address.
Yeah.
So we can provide the notice by email.
Yeah.
So
Great. Perfect. Okay. So let's see. What that do?
no, it's just the keyboard, if that's easier.
Oh, but I don't have the keyboard. This is my keyboard.
Oh, yeah, that key's right here. Start the arrow buttons there.
I didn't look to see if I went too far.
So
So then from the city attorney, hopefully we'll give you accurate legal advice and guide on process. And I'm usually a participant in the script. And I want to make sure during the script that I'm there as a resource to you if you're not clear whether you've got a conflict of interest or a bias situation. So I try to guide you through that. Also try to help on keeping the order of the meeting. And as we interact, if there are any issues, follow-up information you need to make your jobs easier, to make the code work better for you and the community. What's needed from the members? Obviously, the more you know about the code and your rules, the better. And preparation for the meeting and giving your full attention to members of the audience and fellow board members as they go through the process. And here's the laws that specifically apply. ORS 197.7, well, I always say 63, but it's been changed to 797. That provides the public hearing process, and that's where we find what is the obligation of the city to provide notice and information to the public in advance so they can prepare and we can issue the decision later on. Then there's ORS 244, which deals with conflicts of interest. That's the state ethics law. Now, Tom is a member of the Planning Commission, so you get to fill out that statement of economic interest each March. But it doesn't reach down to HRB members, which is interesting. I wouldn't be surprised if sometime it might.
It does.
It does now?
Yeah, it has since I've been on that.
Oh, it has. Okay. Okay, Ron. Thank you. I'm going to note that as that's education for me. I didn't realize that it went beyond the Planning Commission, but good, because you're involved in land use procedures.
Absolutely.
It certainly makes sense.
Yeah.
and ORS Chapter 192, Oregon Public Meetings Law and Public Records Law. So you're responsible for making sure that any meeting is conducted within the public meetings law and records law. What that simply means is, for a public meeting, we need to provide notice of the meetings. We need to make sure they're accessible to members of the public in all ways, that people are able to participate. And participate means that they're able to be present or to virtually watch the meeting take place. Participate does not mean that a member of the public gets to interrupt and give input throughout the meeting. You have the ability to create time, place, and manner restrictions on when public information is given. And within the land use context, there's always the requirement that there be the ability for the public to participate. In city council meetings, not all agenda items that the council puts on the agenda have to have public input. Public records law means that anything and everything related to a public action needs to be kept. If it's a writing, if it's a recording. For instance, the notes that you're taking tonight technically are a public record. And you've probably already heard that before. So theoretically, well, you know you are. You're holding on to all of your public records, and at such point that when you leave the board, you might provide those records to the city staff, and they may maintain ones that are unique. If you've got duplication, you don't have to submit to the staff copies of the staff reports that you received because they already have one. But if you use your staff report and you're writing notes furiously on there and you use that for your decision making, that is a public record. And public records can be requested through a process, and they need to be delivered. And you as a public official, and you are public officials, you have an obligation not to violate the Oregon Public Meeting Law by disposing of public records.
And if you're on your phone texting, they can also look at that too, right?
The texts can be reached too. Phone records of conversations, no. So something like a message that's left is not reachable, but a text is, and an email is. Those are all public records. Okay. So what's needed by the citizens? They obviously need to have the process be one that's open, that they have access to all of the tools that are going to be taken into account by an applicant when they submit their application, and by the board as it reviews the application. You need to see the application that's submitted. Everything and anything that's going to be considered as part of the record that's before you for your decision needs to be available to the public. Obviously, we strive to have the most easily understood procedures that we can, and your code has been developed over many years. It's been tweaked on a regular basis. And a lot of the housing standards, as you probably have heard, are becoming even more clear and objective because of state law. Clear and objective standards, however, I heard John say this the other night at council meeting, does not mean that it takes over in the historic review area. But if somebody's building a new residence and wants to build a new residence, those need to be clear and objective. What that means is we're taking away a lot of the standards that might say, well, you can get approval if it's consistent with the development pattern in the surrounding neighborhood. That's not clear and objective. So those are going away. Well, things such as numbers, like it has to be 10 feet away, can be no more than 30 feet tall, no more than 30% of the floor area of the lot, those types of things. The other things that citizens need is they need to be able to get to the staff and speak with the staff and understand what's going on the application and understand the schedule and how to participate in the process. They need to be able to get the comprehensive plan, the code, and all the application materials. And Westland does an excellent job of putting all of those available on the website, so they're reachable. And they need an unbiased decision maker, and that's where you come in. And that's where we need to make sure that everyone is aware of their responsibilities to make that happen. And then there needs to be due process. And due process means that when there is an application, the participants need to be aware of what the application is, what the criteria is. They need to know how to participate. They need to be able to rebut information that's submitted in support of an application. They need to know what the decision is that's made by the board, And they need to know why the decision was made, because they need to be able to then consider whether or not they, if they have standing, want to consider appealing the decision. They can't appeal the decision if they don't know how the decision was made and what it was based on. And of course, on the flip side, the clearer the decision is as to why it was made, the more likelihood that an appeal won't be filed, because people can read it and see, well, okay, basically that makes sense. I can see why they did that. So here's the procedures. As I mentioned a little bit earlier, excuse me, there's two types, legislative and quasi judicial. And when you're involved in the legislative process, that's where you're making a recommendation on a change to the code or a change to the plan, and you're not the final decision maker. So your input is valuable, but you're not bound by the same regulations that you are as when you're a quasi judicial body. When you're involved as legislative, we want you as community members to gather as much information as you can from as many sources as you can. If you want to reach out to every other community in Oregon and find out how they're doing it, if you want to talk to all your neighbors, you can do that. And you don't have to, at the meeting, declare if you did all those things. You can say, certainly, I've educated myself as best I can. I think I've done a good job. And you don't need to go through, I've talked to this person, this person, this person. Here's what input they gave me. Different when you get to quasi judicial. Okay. And ex parte contacts are right with the legislature. So people can reach out to you. There's less restrictions that apply.
Can you talk a little bit more about people can reach out to you?
Sure. So they know you're an HRB member, members of the public. They know that you're considering a legislative change. Members of the community might call you and say, I know you're looking at modifying the code language for how a historic property is going to be, and we're talking in a general sense, how it's going to apply in the future. So here's what I think. They can give you that input. When we switch to quasi judicial though, and now it's the application of the existing code to an actual application. If someone reaches out to you and says, I'd like to talk to you about the pending application and what you're feeling about it, that's an ex parte contact. That you have to report on the record.
Even if you don't respond?
Well, depends on if the person calls you and says, I want to talk to you about it, I would still put it on the record that I was contacted by a citizen, as much detail as you can. If they identify themselves, someone you know. And I would say, I was called by Joe, but immediately when Joe said that he wanted to talk to me about the pending application, I said, you know, I can't talk to you about this. This is an ex parte contact. I'm going to have to declare at the meeting, but please come to the meeting with your input. But at the meeting, you want to say, I have that contact, because it's possible somebody saw you or heard that you had that contact, and their assumption might be that you went through a long, elaborate conversation. So be the first one to get it on the record. We didn't talk.
Our emails are public record, and sometimes you get kind of unsolicited emails. So every single one of those have to be,
Yes, those are,
every single one we'd have to document.
yes.
So I don't email people.
Yeah. So I think also too, if specific questions come up about
That's the
application in the future, you can reach out to Darren Weiss or myself, and we can connect with Bill or someone else at the city attorney's office and walk through the spirit.
So let me make sure I'm clear. I'm giving you the most conservative
Yeah, I understand.
answer that I
Oh,
can.
yes.
Yeah. Practical is a different story, but try your very best that when people reach out and send those emails, when you get to a meeting, if you have received 50 emails, right, if you have sent them all on to staff and said, I received numerous emails, I sent them all to staff, they're all in the record, I wouldn't feel that you need to go through each and every name
list it all
if you
out.
didn't respond to. Okay. So in the legislative process, yes.
So we forward emails, unsolicited emails to staff. Do we call them or let them know about voicemails that we don't respond to?
Let me ask you this, do you get a lot of these?
I'm brand new.
Okay.
I'm
It's
learning
happened
from you
with
all.
certain projects that it's sensitive,
So,
then yes.
so excuse me, if you get a call, and so you pick up the voicemail, you listen to it, you're not going to call back, and you don't call back. It's not a full contact that's been made because you really haven't had a conversation. However, your mind's starting to race and you're starting to think, oh, Joe's interested in this application. I wonder why. Just for your own safety, I guess, if you're most conservative, I would report it. I would
So
put it-
just like a quick email to John, so-and-so called me.
Yep.
Unreturned.
Yes.
Okay.
So I do business with some of the people that are applying for things. An example would be Icon. They were the ones with the large building that we last month.
Yeah.
I do some business with them on a residential level, but I ran into Darren, who was the applicant at Garage Food Trucks. And both of us didn't talk about anything, but in my planning meeting, it might be in my best interest to mention, I ran into the applicant at a restaurant. We know each other through business. And we did not talk about anything that applies to, however best worded, but that kind of makes me think, because I don't know that I would have reported that necessarily.
That's absolutely the best advice I can give you.
Yeah.
The exact way you define it, because we know that when you're out in the open, someone sees you and the first assumption is the only reason you're talking is because that application is coming forward. I always use the grocery store example that you're at the freezer and you're talking to somebody and you might be talking about your kids are both going to be in the same soccer team, but that's not what member of the public thinks.
Yep.
So it's easy to get it out in the open, make the statement before someone makes an accusation. Because as we're going to talk a little bit later, there's a process here for how to deal with someone raising a challenge to you.
Yeah.
Okay, so thanks for that, because that was a great example. Findings are necessary for legislative applications. So you don't need to worry about that because you're not making the final decision. But I emphasize that because I had a matter I worked on for West Linn back around 2008 or 9 where there was a long involved process to change some regulations about size of homes. Actually, that's what it was, size of homes. And no findings were attached to the application, or rather to the decision. So when it was appealed to LUBA, we were able to pull out of the record enough information to support the decision, and we won at LUBA. But it would have been a whole lot simpler and less expensive if findings had been clear as to, rather than have lawyers have to put the pieces together and file a response.
And LUPA is.
LUBA is the Land Use Board of Appeals. So if a decision of the Historic Review Board goes through the city council and is then appealed from the local level, once the decision is made locally within that 120 days, the next resource in Oregon, it's a unique process. There's a unique land use board where appeals go to. In most states, it goes to the circuit court or goes to the Court of Appeals, but in Oregon, it goes to the Land Use Board of Appeals, which is a body of 3 administrative judges. They're not judges, they're hearings officers, but they're lawyers, and they're appointed by the governor. And there's a process that if someone wants to challenge a local decision, they file what's called a notice of intent to appeal within 21 days of the decision being made, or there's some legalities there. Within 21 days, they file a notice of intent to appeal. Then the city has to compile the record of everything that's involved in that land use decision, submit it to the Land Use Board of Appeals, and to the appellants, and to any other parties, and the applicant might be a party. And then there's a briefing process to make the decision. There's no more hearings other than lawyers talking. But that's the next level. And then if that's appealed further, it potentially goes to the Court of Appeals. So it's a process that West Linn unfortunately has a lot of experience with, but we've been lucky the last few years that there haven't been many. Findings are important for those decisions because that's when LUBA reviews a decision, they're restricted to looking at, did the city follow its process? Did they have adequate findings to support the decision? It's not whether they feel the decision is right or wrong, it's did we follow the prescribed process and apply it. Okay. So, I guess I need to use this map as a switch. Quasi-judicial is different. That's when you're sitting like a judge or like a jury. The 5th and the 14th Amendments require due process, and what due process requires that there be impartiality. So we have to treat everybody fairly. Everyone has an opportunity to participate in the process. The parties need to know what the decision makers, namely you, took into account when you made your decision. So they need to know what you're reviewing, the application, the supporting documents, the code requirements, what you hear in the public input, what you get as input in those ex parte contacts. Anything that could influence you needs to be in front of them so they can challenge it and be aware of it. Ex parte contacts have to be announced so all parties know the information that was provided to the receiver. We'll get to that. Let's see. Oh, and also information considered by you should be factual. So that's your job to determine that number one is factual. And you're also going to be doing some weighing because you're going to be getting information from various points of view. And you're going to be trying to make a determination. Well, what is what we call substantial evidence to support the decision? Is it something that a reasonable person would take into consideration when making a decision? If somebody says, well, you just can't do that because they don't do that in Lake Oswego. Okay? That's factual, but has nothing to do with your regulations, in the quasi-judicial process, information placed before you can be challenged by the participants. So within due process, there's always the opportunity for rebuttal. So within your process, the way it works, staff and the applicant make their presentation. Then the members of the public speak to what the applicant said. That's both their opportunity to give input and their opportunity to rebut. That's their rebuttal opportunity. Okay. At the end of the process, the applicant always has the opportunity to rebut all the comments that were made. So what you do usually is all those in favor come up and speak, all those opposed. You don't have to do it that way. That's the best way to do it, I think. But some communities, they just go down the list and give everybody an opportunity to speak. But the applicant has the opportunity to rebut at the end. Yep. The applicant also always has the final word. But they need to know what's in the record if they're going to rebut. So when the applicant gets in front of you, what I always recommend is don't let the applicant off the hook when they say, John did an outstanding job. The staff report, he covered everything. I agree with everything he said. I'm open for question. It's the burden of proof is on them to prove to you that they've met the application. So don't let them off the hook. If they do that, well, hopefully you've got some questions to say, well, could you tell us more about your application? Because John did a great job, he always does, but he's not selling the product. So the information should be factual. Also, the process should allow information before the HRB to be challenged, and for people to be challenging, they need to know what's there. So what's there. Your municipal code requires the HRB to conduct its meeting in accordance with the council rules. These council rules will tell you what a quorum is. They'll tell you what is necessary for an approval. Strangely enough, there's well, I don't know how deep I want to get into this. In some cases, these council rules, of course, are written for the city council. It always says city council shall and must and blah, blah, blah. Some of these rules really only apply to the city council, and I really don't want to suggest that they get extended to you. For instance, there's one provision that if council reaches a deadlock, they can't get beyond a tie vote. Planning Commission's decision becomes the decision of the city council, and that's what applied to the Athey Creek School. I wouldn't want you to apply that. And I think that really was intended only for the council, because again, it's only relative to Planning Commission. So don't try to apply that to local, for your level.
We're just a recommendation body, really, though, right? We would just be still our recommendation that.
There are some applications where you are the deciding authority.
Okay.
Yeah. So a decision has to get rendered. You can't revert back.
And so what if the decision can't get rendered? That would just still go Planning Commission for a tiebreaker?
Well, okay, there's another provision in here. I'm thinking two things at once, so excuse me. You actually don't have a body below you that section that I just talked to would apply to. But if you have a vote that is a deadlock, there's a provision within either the council's rules or in your rules.
Yeah, because we could end up with an even number.
Yeah,
Right.
but if you can't get beyond that, okay, so
Yes, we go to planning commission. So.
It
yes,
would-
we're gonna go to planning.
I think it would go up to the council.
So you go to cancel?
Right, no, I'm sorry, it would go to the planning commission. He has to go to council, but I think it would go to the planning commission if you get a deadlock. Pretty sure of that, but I don't have that citation. If we have time later on, I might be able to get it to you. So section D, the council rules. Oh, so what I want to say about the council rules is that in June, they were adopted, June of 2019. They're being reviewed right now, but the rules that the council has been looking at will not affect your decision making. They're mostly about public input. But keep an eye on those. But when there are challenges made, and this is the point that I added to this, in the script, we'll go through the process and ask, does anybody have a actual or potential conflict of interest? Talk about that. A bit. There's also a place where this question, anyone have a bias? And actually, it's all in one question, but is there conflict of interest or is there a bias? Conflict of interest is when there's a financial interest at stake. Is it a possibility that once this decision is made, whether it's pro or con, could it financially affect you or your property or a relative of yours? And you know from having seen the state ethics rules, there's a lot of relatives and members of the household that are affected. But if we get to that process and we ask if there are any declarations of bias, but a bias is a relationship. It's an issue of relationship. Tom knows the person who's the applicant. He's worked with them on other things. He declares that he knows that person, but he hasn't talked to that person about this particular application. Ideally, he's going to be able to say, I'm going to judge this based on the criteria, and our relationship doesn't come into play. But a member of the public then has a chance to challenge that. That's the next step. Does anyone wish to challenge the declaration of conflict of interest or bias? Someone might raise their hand and might say, I want to challenge commissioners, board members, declaration of bias. I think there is a bias. Well, what happens? Well, under our rules, the council's rules that apply to you, there's a provision on page 18 under section D1, bias to qualifications, D1A says any person may challenge the qualifications or impartiality of bias of any counselor, or in this case, board member, about to participate in the decision. The challenger has to state the reasons why they feel the person is biased, and they may just say, he's worked with them for years. He can't change his mind, and makes that statement. Then the presiding officer has to give the challenged counselor or board member the opportunity to respond. That would be the time for the person to say, these are the reasons why that's not accurate. Then, after that, there's a vote to accept or deny the challenge. And that's what's unique to Westland. And we've gone through this at the city council recently.
This happened a few years ago in the,
Happened here.
it's happened in many
Yeah.
times. See the
So,
story.
yeah, so what you do in that case is the chair, as long as the chair isn't the person being challenged, the chair or someone else in that case will preside over having a vote. And it's a simple majority vote. And the person, of course, is challenged doesn't have the right to vote. And that's the end of it. We make a record of it. The second thing comes into place when there's an ex parte contact. That's a little bit different. When there's an ex parte contact, I'll just go right to that since I'm already on this. Similar situation. Person declares the ex parte contact, and the ex parte contact can either be a physical contact by an individual or it's a site visit. And I say that in a conservative way. I believe site visits are ex parte contacts. Because when you go out there on your own, even if you don't encounter the property owner or a neighbor who gives you input about the property, you're seeing things that could be unique that you didn't see in the application, that John didn't pick up, or that it might be seasonal, that he did the review 3 weeks before, but something's happened because of the weather conditions, and you see something, and it's important to you, it's going to factor in, you need to make that declaration. Well, if there is an ex parte contact or the like, the same situation applies. Does someone want to challenge that? Then the counselor will state whether, oh, it's a little bit different. So using board instead of council, the board member will state whether the contact affects their ability to vote on the matter in an impartial manner, and whether they will participate or abstain. So you've already made your comment as to what happened, what the contact was. But to meet the letter of this, you need to state whether it affects your ability to vote and whether you participate or abstain. So that's your option. But even after that, the presiding officer announces the right to rebut that. That's where it gets sticky. Now that member of the public who's raised the issue has a chance to rebut that comment. So what the chair has to do is not have this become a back and forth. Yeah, control it as much as you can. Only let the person speak when they're asked to. And then the council determines that whether or not the council should step down. So same thing with the vote. Okay. Good. All right. So I'm going to have to move along a little faster because where are we on time check?
It is,
15 minutes. Okay.
it's 10 to 7.
Not so bad. Okay, so the elements of due process. Every person who comes to the hearing has the right to present evidence as well as to rebut the evidence presented by other parties. But that doesn't mean that the first speaker of those people giving input gets to rebut the comments given by all the people that follow after them. Okay, that's not what that means. The HRB has the right to do those time, place, and manner restrictions and to create the order for the presenters. That's up to you. But to rebut evidence, a person needs to be aware of what the evidence is that's on the record. So they need to either see it, hear it, or some way can get aware of it. Here's what the record is. It's anything and everything that is submitted in a written manner, the letters, emails, minutes of the hearing. Sometimes that's important, particularly if there's a continuation of the hearing. The tape or video of the hearing, that's Zoom or WebEx. And also the decision itself and the conditions of approval are the record. And that would be if it's going to be called up by the city council or she goes to move it. Think about if a decision gets called up on appeal to city council, they are not restricted by the record that you have. They look at appeals de novo. De novo means new. They conduct a whole new hearing. But your information is important to them because they trust you as the local experts in interpreting the code, because council members have got so many other things to do. The knowledge of the code as applies to HRB might be somewhat limited, but they still have to hold a separate hearing, which means the same participants and even more people can participate. You're not limited to participate at an appeal hearing if you didn't participate at the HRB, not in West Linn. So it's everything that's placed before the HRB. And I've already talked about all those things down below. Important thing on the staff thing, the notice of the hearing, the staff report, anything and everything that the staff receives, they put into the record. Usually it's available before the hearing for members of the public to review. And any letters and testimony and all those emails that you might receive and pass on. Okay. Procedural items. So the notice of hearing, what's in it? So it's going to say where the hearing is going to be, what the application is, what applicable criteria apply, who the applicant is. It also will, it's important to know who it's going to be sent to. That's not in the notice, but somewhere the city code will say that people within X number of feet are going to receive a copy of that notice. And this staff report, which is available online, but it's always sent to the applicant and anybody else who's asked for a copy. And all these other items are right to continuance. So the way that the Oregon statute works, there have been negotiations over the many years. Oregon land use system came into effect around 1976, and then every city and county had to develop some comprehensive plan and development code. So West Lynn's has many unique features, although it's also been built and taken elements from other cities. But because of the terrain in West Linn, you have a lot of features that are very unique to us. But the way that the land use process has worked in the early years, applications clogged up the system. There are many applications. I came to Oregon to be the planning director in Tigard back in 1982. And Tigard was hot with activity. It was 13,000 people when I got there. Other than now, there's 55,000. So theoretically, there's been a little development that took place, and a lot of activity came in the doors. But for the first years of the development cycle, there was so much development activity, applications were taking 1 year, 2 years to work their way through the system. So the development community spoke up to the legislature and said, we need to have more certainty. And that's where the 120-day rule came in. But when the 120-day rule came in, to require that cities have a more expedited process, and there's a couple off ramps that cities can use. There also was an agreement that if the city follows the rules and provides proper notice, then it is entitled to something. And what it's entitled to in return is that statement that we make in the script that says, failure to raise an issue, it used to be failure to raise an issue with sufficient specificity so the decision makers and others are able to respond to the issue raised. The compromise was if the city has that statement, and the city follows its proper notice, then it has certainty that at the end of the process, someone can't file a lawsuit or file a challenge to LUBA and raise something that they didn't bring up locally. So that's why there's all of this process, because it's developed over the years. So Oregon has an emphasis. Citizen involvement is rule number one. One of the other rules is economic development. The only way to make it work is to work out something. So it's important that we do the notice requirements. I trust John. We've never had a challenge of the notice requirements. My job is to help you through the process so we don't have challenges to the procedures itself. Because if something goes to the Land Use Board of Appeals, they are either going to find that the city followed its procedures properly, and they're going to affirm the decision and the development takes place, or they're going to overrule the city and reverse the decision, which is a really bad thing, because that means the city didn't follow its rules, and the city is also going to be paying some serious damages, or it is remanded. And the remand is something was done procedurally wrong, or something was missing from the record that should have been there. So LUBA says it can be fixed, but it has to be fixed, otherwise the decision cannot become final. It sends it back to the city sends it back to the decision maker, who holds another hearing, and there's an effort to see if it can be fixed. It may or may not. It typically does. Okay, so the staff report, okay, so we make all these statements, right to continuance. With all this, there also was added several years ago, is an automatic right to a continuance of the hearing at the first evidentiary hearing. You're the first evidentiary hearing. So the first hearing that you have, that you open up an application, if anyone, for whatever reason, they don't even have statewide, somewhere before the end of the hearing, even if you're going to continue to another hearing, someone says, I asked for a continuance, you have to grant. That means we have to either have another hearing, or if you're able to, if you're at the, well, yeah, we have to have that. We have to continue to. If someone asks for a continuance at the second hearing that you have on an application, or if the planning commission is, well, the city council rather, because if an appeal of yours goes to city council and someone asks for a continuance and it's been before the HRB, well, that was the evidentiary hearing. It's not a each level, or the planning commission, it's not at each level is a first evidentiary hearing. It's the first one's held at the city.
Wait, so you got to say that again. So HRB did a continuance and council would not be able to.
Well, I take that back. City council is not required to grant a continuance if someone asks for it. It's not mandatory because it's not the first evidentiary hearing.
We're the first evidentiary.
Right.
We're the only ones that really apply to it.
Yeah, wherever the first evidentiary hearing took place, that's where the mandatory requirement of stop the process. Interesting.
Did you say that any time during the meeting?
Well, that doesn't stop the meeting. They can make the request at any time during the meeting that there be a continuance, but it's up to you as to how far you want to go in taking public input before you deliberate towards a decision. You have to have the continuance takes place before you close the record of the hearing to have the deliberation. Before that, someone can ask for a continuance. But again, if they ask for it right off the bat, you don't have to stop it. If the applicant asks for continuance, then I would consider stopping the meeting, because why would you want to take the public testimony? If the applicant wants to continue, they want to come in with more information, why do it twice?
Yeah.
So the board members can ask for a continuance.
Well, this is for members of the public. You shouldn't be asking for a continuance unless you get to the point in the meeting where you're deciding whether or not you're going to close the hearing. So when you go through the process, you've had public input after the staff and the applicant, public's given their input. Then the staff's going to come back up and you might be asking questions, clarification, not new information, clarification. But if there is some new information that you need, you might say, people have raised this issue about the impact on this has at such and such. I don't remember seeing enough documentation to know what that is. I'd like to have more information on that. I, as a member of the board, would like to have a continuance for more information. That's a request that then the board gets to consider, but that doesn't fall under the statute. That's not that mandatory one. That's the right of other participants. Okay. Scripts. So what we typically do, John prepares the script, he sends it to me, sends it to the chair, and it'll list what the applicable criteria are in it, all those usual things. And there is a point within that that actually has if a continuance was asked for, how to deal with it. Some cities provide the script to all board members, and they also have some sample motions. I don't think you do, but no, I'm not sure if that's best. Well, that's better than this. No. Elements, pretty straightforward. The opening statements, legal matters, testimony order, presentations, public testimony. Little questions, deliberations, and sometimes sample motions will be listed. Then final comments. Final comments are important if it's the final decision, because we want to say what the appeal rights are. What we emphasize to the council is we try not to say what the appeal rights are if you go to the Land Use Board of Appeals. That's their rules. They might change those rules. We don't want to be responsible for that. I'd say we say, if you want to appeal there, call them. They'll help you follow their rules. But our local appeal rights will be in the decisions that you make.
In terms of the script, if you're interested in seeing the script, we usually just provide it to the chair, but happy to share it to the whole.
They're kind of handy. The planning commission, we do share.
Okay.
You've been involved in that where
I have, yeah.
just some procedural things.
Okay, yeah,
I mean, that way, it helps, the new members.
absolutely.
And,
Okay. Hope you anticipate this.
Yeah.
So I can do that then, so.
another thing, can I just mention one other thing? You talked about what was the email that we get in March?
Yes, statement of economic interest.
Yeah, so when I first received that, I thought it was junk mail years ago, and I ignored it for a little while. off.
Did you get pinged? Did ping?
And I got a $50 fine days
Yeah.
later, years later to track. But so there'll be an email coming to you that I.
I've already done it. I think Lynn said, by the
Okay.
way,
So I
we
was,
need to do that.
I was not aware of that. I mean, so I just want to make sure new members are aware of it.
Yeah, the interesting thing on that is, I think it's March 30. If you're in office on March 30, you have to fill it out. But if you resign on March 15th, you don't have to fill it out. If you're in office on March 30, you just were appointed right before it. You're making declarations of things that took place a year before.
Yeah.
That you may or may not have been keeping track of.
Yeah.
So it becomes a little challenging.
I think I received it before I'd been told I'd been appointed. So it's like, oh, I guess I'm in.
Congratulations.
So yeah, yeah.
So now we'll go to the impartial tribunal. I covered much of this, but I'm going to talk about the procedures that we need to follow. So we talked already about ex parte contacts, and there's the critical elements of it. That someone who's a party, they care about this application, to a fact about the application that you're looking at, makes contact with you under circumstances that don't involve all parties to proceedings. So we always emphasize, for instance, again, taking the most conservative route, but we always emphasize, do not talk about the application with anyone before the decision is made. So if there's a continuation, you're leaving the council chambers, and someone comes up to you and says, hey, I want to ask you a little bit about that. That's a ex parte contact. That needs to be declared at the next meeting. So it's best to not engage in that conversation if they want to talk about something to do with these proceedings. All three of those elements, that it's a party as they care about it, that's party is someone who cares. And it's about something related to the application, and it's outside of the proceedings. Those are the elements that have to exist for an ex parte contact to be played. It can be oral or writing, and we discourage them. I discourage taking a break during the meeting and then have members of the committee interact with the crowd. Luckily, you have a door that leads back to where there's a restroom and there's a room, lunchroom. Theoretically, it'd be best if we go back there rather than walk through the crowd and go out into the lobby if it's a huge crowd. Because again, you're going to be talking to somebody because you're the coach and somebody wants more playing time for their kid. But somebody thinks that they're really talking to you about that. Okay, so if they occur, there's some action that you need to take. And if an ex parte contact takes place, you have to disclose it and put it on the record. And you have to put it on the record at the next hearing on the matter. Now, the next hearing on the matter may be the very first hearing, because you were contacted before the application is in front of the board. But at that first meeting, after the contact is made, when the time comes up, you need to make that declaration. Now, let's say you're contacted by somebody who you don't think has any interest in this. So somebody from out of town. They live in Milwaukee. And they say to you, I understand, I saw that you're in the HRB, and geez, somebody told me there's this application coming up. And what do you know about it? You're not thinking anything about it. They're not an applicant. But then you see them in the audience and you realize, oh, they work for the company or they have a family member who's here. As soon as you know that there's a person who's a party who has an interest in this, you want to make the disclosure. So if you missed it during the script reading time, first opportunity you have, I recommend that you interrupt the chair and ask the chair, Chair, I need to now make a statement. I didn't realize this, but there's a person in the audience who now I recognize, oh, they just got up to spoke, they're getting ready to speak. I recognize that I had an ex parte contact. So you need to reveal the contact and the substance of the contact or the communication, and that has to be recorded in the records within minutes. Same thing for conflict of interest. They have to be within the minutes. And the chair needs to follow that section that I referred to if there's a challenge to the ex parte contact. So whenever there's an ex parte contact made, even if it's after the script is read and there's one that's made, the chair should say, does anybody want to challenge this ex parte contact? Just to clean it up then and get it done. failure to make a disclosure of an ex parte contact could result in a remand. It won't result in a reversal that you don't want to put the city through that. Site visits, I already talked about this. They are, in my mind, and I believe most attorneys believe, ex parte contacts. And make the disclosure as early as you can on the record as to what you saw and give as much detail. So what I typically do, a person will say, I went by the site. If they say, I drive by every day on my way to work.
It's only if like you get information that this site's gonna be actively worked on.
Yeah, you know.
And then after you understand that, then you go and visit the site, right?
Great point. The process starts when you know that there is or is likely to be an application.
Right.
For this. That's when the point of ex parte contacts begins. So if you drive by on a regular basis, you're not looking at it from the code requirements, that's not a problem, although most people like to make that declaration, that's great. But if you decide you're going to stop there and you're going to look at things, you may have read the staff report and you're starting to look at details. That's an ex parte contact. Tell us what you saw. And what I'll typically say is, did you see anything that is different from what is within the staff report or the application? And if you tell me no, I'll accept that, of course, and I'll say, but if something does come up that you realize that you saw during the course of the conversation, would you please share it so that all the members of the board and the public can know about it?
It's sort of funny because I did go walk around the Icon block before we met, but today I was looking at Zillow Street View, also viewing it, from the luxury of my computer, which is, almost like that, but different, I guess.
Yep.
Now with Zillow, you can get street views and you don't have to do a site visit.
But you also could
Or
get,
Google Earth.
but you also could get something that's out of date.
You could.
Yeah,
Yeah.
because I recently looked at my house and I saw a car the picture of a bauble that I gave away 3 years ago.
Exactly.
So it's important to make those declarations because also you may say
Yeah.
that you made a site visit and you're saying, I just don't believe you. There are so many trees on that site, you might have been at the wrong site. Which gives the ability of staff and your fellow board members of the community to say, wait a minute, we're at the right place.
But you don't mention computer viewing.
It never has come up before.
Okay.
Um,
I was doing it just to familiarize myself with
Yeah,
three
it-
sides of a site, like, okay,
Yeah,
where is
it is,
this?
it's evidence that you've looked at. It's not a site visit. It's more of the ex parte contact than it is of the site visit. The numbers are asking that question.
It's just a new virtual.
Sure.
look.
Right, and it's probably going to become an issue that someone raises, so. Okay, so let's move on to conflict of interest. And as I said on conflict of interest, there's got to be a financial issue related here. Potential conflict is when it could occur, that if the decision that's going to be made on the application could affect the value of your property or one of those people that falls within your relatives, then you need to declare it. And you need to declare, what's the reason that you're making the declaration. However, when you make that declaration, if it's a potential conflict of interest, that doesn't mean that you have to abstain from participating. Someone can challenge you, I'm going to go back to that slide. Someone can challenge you and they may say, you might not think it's going to affect your property, but I'm darn sure that it is, and here's why. You might want to take that under consideration, and if you're starting to think that, well, maybe they're right, I haven't really thought of that, you might want to reconsider whether you're only declaring a potential conflict. Now, I want to make one thing very clear for everybody who's here, including those on virtual. If you think that you've got an issue with conflict of interest, please, if at all possible, contact the Ethics Commission staff and tell them your situation and ask them if they think that you've got a conflict of interest, an actual potential. Because if you ask the staff in advance and if you tell them all the facts accurately, and if you follow their advice, you get some level of protection. If you contact John, you contact me, that doesn't get you any protection. Your city attorney doesn't provide any protection for you on issues related to ethics and conflict of interest. Okay. The other type of conflict of interest is actual conflict of interest. And that's when if you participate in that decision or action, the result of that decision, whether it's to approve or deny, would result in a financial gain to you. So if the denial of the application preserves your value, or if the approval of the application might be detrimental to you or enhance your value, it's either way, you can't participate. And it may seem odd to you that, oh, it's going to impact me. I could lose money if this is approved. Yeah, you might. Doesn't mean you have a right to participate. And it applies to you, your relative, and your business, and all those others. But it has to be that you know it's a definitely will happen. With potential, what should you do? You announce the potential conflict of interest before you participate in debate. So ideally, you'll be able to do it during the script. You announce that potential conflict, and then if it comes up during the hearing. So for instance, let's say you don't realize that your brother-in-law recently bought a property that just happens to be across the street from this property. And all of a sudden your brother-in-law is in the audience as a participant, and you recognize that, and your brother-in-law is one of those people, pretty sure it still is. At that point in time, try to get that on the record. And if it looks like it's a potential conflict of interest, again, you can participate. When there's more than one hearing, you have to make the announcement each time the matter is on the agenda, so that the participants at that second meeting hear. Actual conflict of interest, what you should do, you cannot participate if there's an actual conflict of interest. It's not your option. You have to refrain from participating. You have to make sure the declaration is within the minutes. And you have to make that declaration at each meeting. So even if you're at the first meeting, you declare, then you come to the second meeting. Even if you're not going to participate, make the same declaration for the meeting. And my recommendation always is leave the room. Because people are going to be watching you if you stay in the room. If you stay up at the dais, it's going to appear to the public that you're part of the decision making. If you make any facial movement, nod your head, act disgusted when somebody makes a comment, that's going to be all interpreted. Leave the room.
So our last meeting, I recused myself for planning purposes. I sat in the back of the audience. I should have probably left the room.
I'd recommend you leave the room.
Okay.
Because other members of the board or the planning commission can be looking at you.
Sure.
If they think you know more about an application, they may not be doing it consciously.
Oh, I get it. Okay.
So don't let the public be connecting the eye contact.
Okay. Thank you.
And then come back to the next item on the agenda, because you don't get a free pass to get to fruition. Exception. So there's always an exception, and I don't like the exception.
Which is it's the minimum.
Yeah, so you have to be able to take an action. So ORS provides an exception if it's necessary to have enough participants. But necessary to have enough participants does not mean, well, so-and-so's on vacation and somebody else didn't make the meeting because they're sick. You can always have a continuance to get those people involved in the decision making. And I suggest you do that if you get a quorum problem. But if you had a quorum to start the meeting and now one person or two people have to declare a conflict of interest, is what's called the rule of necessity. And actually, I had to apply this early in my career at a city where their city attorney had a conflict of interest. So I had to go down as visiting city attorney. And in this particular community, they had like 7 members of the city council. And in this community, almost everybody either worked for the big company in town or they had a relative that did. Wow. So what we had to do is we went through a process. Declaration. Some people, they had a bias. I worked for that company. I don't work for anymore, but I don't like it. And someone else, they had a conflict of interest, actual potential. If you go through that process, what we want to do is to restore a quorum if we can at all. So what we try to bring back to restore the quorum is the people with the least issue first. So the person that had the bias, we'll try to restore them first. Will you participate? Because if you have a bias, you can decide whether or not you want to participate, right? But if a person said, I don't want to participate, well, we might want you to. Will you consider now, and as you go through this process, I'll come back. Well, if you're still lacking, then you might have to look at the people with the potential conflicts of interest and see if you can get one of them restored. So it's legally possible. I don't recommend it. And in your case, you already have a provision that says if you're deadlocked and you can't get a quorum, it pops up in the city council. But just so you know, fun fact, doesn't it? Personal bias is when a member can't render judgment because of an acquaintance with someone or something in the land use case. And in a bias, you have the right to decide whether or not you participate, unless you're challenged and your board, votes you off. But we want you to hopefully be able to say that regardless of any relationships I have, I'm going to make the review of the application and my vote based on everything within the record. And you make the disclosure. And there's that process that we just talked about. Okay. So it's all there. So I've never talked to the chair about this because this is within the council rules. I haven't seen it play out before. But this is what hopefully the incoming city attorney will recognize and follow to. Written approved. So as I said before, the applicant, the proponent, has the responsibility of convincing you that their application meets all of the applicable criteria. And the greater the change proposed, usually there's a greater burden. And that's met by them submitting their application and all the supporting information. Your job is to make a decision to either approve something, deny something, or to do something with conditions of approval. And it's important that the applicant be involved in that condition of approval by being able to give input if the issue comes up. If a board member says, well, I don't see this can work unless such and such occurs, you're going to want the applicant to be able to give input to that. If you fail to give the applicant an opportunity to comment on a proposed condition of approval that wasn't within the staff's report, the applicant has the ability to jump over and go to circuit court, challenge the imposition of that condition of approval. They weren't given the opportunity to rebut the process issue. So the applicant should respond to any issues raised by opponents. So you've given the opponents a chance to speak. Now they have that rebuttal time. The record's not going to be clean if there are issues that were raised and they don't get up and address them. They need to address them, though, without providing new evidence. They can't come up and address the issues raised and say, well, in consideration of that issue that's raised, I'm willing to modify my application and I'm going to add another whatever. That's new evidence. That new evidence requires the ability of the public to be able to rebut the new evidence. They can't just leave it to you as the board to say, oh, well, that makes sense. We'll go on with it. That's a procedural irregularity.
Interesting.
So when they rebut, they should be restricting themselves to respond. Rebuttal is that they're rebutting information that was given by the other people. A lot of times applicants will remember, oh, I forgot to say something. We have to slip something in. They technically shouldn't be able to do that. Unfortunately, sometimes when I'm watching the meetings, I'm trying to keep the process going. I can't remember and know whether in John's 30-page report, whether that was covered or not. So we rely on each other to raise those. Again, the applicant should not rely solely on the staff's presentation. And if they provide new information, the public has to be given the opportunity to rebut it. This is just a basic one about public testimony. Don't think there's anything that I haven't covered there. Making a decision. So, okay, so now you get to the point. You've heard the staff's presentation, you've heard all the public hearing input. Now, what are you going to do? Usually what the chair does is determine whether or not there is sufficient information for the group to make a decision. And this would be your opportunity to say whether we need something else. It's something that was raised that I'm not sure this is in the materials here, and maybe you ask John and you go through a process and determine that, no, there's just not enough here to address that criteria. By the way, the public, when we say at the beginning of the meeting, these are the criteria that apply, we always also say, and any other municipal code or other requirements that you might think needs to apply. Doesn't happen very often, but somebody may be aware of something that we missed. If that's the case, we need to fill the record with a response to that. And that usually requires a continuance of the applicant can address. But this is the point that you get to decide, do you have enough? Are you going to respond to a continuance if one was made at that first evidentiary hearing, or are you going to have a continuance because somebody's asked for it, do you think it'd be valuable to do? If you're going to have a continuance, there are some steps that we can follow. But just so we don't lose sight of this on this slide, if the applicant does demonstrate compliance with all the criteria, then as I said before, you've got to approve it, even if you disagree with the criteria. If you think the criteria is out of date, it doesn't make sense, that's fine, but the applicant has the right to be reviewed on the criteria that existed at the time that they made the application. And so you might have to let them through the gate and then immediately start looking to change the requirements for the next step. But you can't stop them because you don't agree with the criteria. Appeal process. Appeals de novo to the council, if filed by the applicant or somebody who has standing. Somebody who has standing is someone who has participated in the local process. Some communities give standing to anybody who receives notice, so they don't even have to come through the process. But here, you have to establish standing by either sending an email or a letter, providing input, or you come and you speak at the meeting, or you sign the form. We allow people to sign the form that says, here's my name, here's my address, I want to have standing. That's all they have to do. It's allowed. The appeal has to be filed within the appeal period in writing. It doesn't have to state the grounds or the reason for the appeal. And that's largely because it's a de novo hearing. If it were an appeal on the record, which would be typical in some communities where the council is only looking at the record that you provided, that not having a whole new hearing, they're just looking at the issues that were raised. So they want to get it narrow. That's not how we do it here. We do it de novo, which is fair, I think, to the community. Anyone who established standing has the right to participate in the city council appeal hearing as well as anyone else. We don't know. And the council gets the entire record. So they get everything that you have had and a new or revised staff report and whatever they get from the public. What's the record? It's the notice, it's the application, it's all the comments, it's the meeting minutes, it's anything and everything that was before you. Allowing continuance and keeping the record open. Okay, so this can get somewhat challenging. When there's going to be a continuance, you're bound by that 120-day rule. Okay, so if at that first evidentiary hearing, someone makes the request, again, it's mandatory. Well, we're in a little bit of a box here because John's going to report to you when the 120-day clock rolls. The applicant's standing there saying, I need the application done now. Hopefully the applicant doesn't play really hardball and say, I want a decision now. I don't care about the request for continuance. You don't have the option. You have to grant the continuance. If the continuance would require that the continuance, by the way, has to be at least 7 days. But if that continuance hearing would go beyond the 120-day clock, and John's going to do everything within his power to avoid that from happening, but things do happen sometimes. If it's going to pass 120-day clock, and the applicant says, I'm not going to grant an extension of the 120-day clock, and they're the only ones that can, they can say, I'll grant another 30 days so there can be this continuation here. That's great if they do that. If they say they're not going to, you have two options. And grant the continuance, put the applicant in the position that they can exercise their rights under the 120-day clock, which I'll get to, or you can deny the application. I would suggest you start talking about denying the application because you don't have the right to have a hearing after the.
Would you need a reason to deny the application though?
Yes, and your reasons would be that you don't find that the process can properly be followed. Okay. Because there's a requirement under ORS that the applicant's going to have. This isn't going to happen. Instead, the applicant's going to provide the 120-day extension. Now, if by any chance the city fails to meet the 120-day clock obligation at some point in time, the penalty for the city is that the applicant gets to go into circuit court and show the judge that the staff had a recommendation of approval. Here's a record, planning commission or the HRB was probably going to approve it. There's no reason not to approve it, judge. The judge looks at that and they're not an expert, but they say there's enough evidence here to me. I approve it. But they approve it usually without conditions of approval. So you lose the right to impose all those conditions of approval. So we do everything within our power to not go beyond the 120-day clock. But our only pressure on the applicant is, well, the right of the commission is to deny it. Well, even if you don't have a kind of off the record here, but even if you don't have a whole lot of good reasons to deny it, use the statute, and the applicant usually isn't going to want to have to exercise their right to appeal to move it. That's not within. So if there's a request for a continuance, whether it's mandatory or it's optional, but you decide you want to do it, my recommendation to you is to be very clear where you are in the process when you are going to continue the process. And again, you have to continue it for at least 7 days to have a hearing in 7 days, or you can also continue it for just written submittals. You don't have to continue because there's a request for continuance. It doesn't mean you have to continue the public hearing. You can allow the continuance that the person has asked for. If you're at the stage that you just are comfortable receiving written information, you can do that. Challenge with additional information being submitted, though, is you don't have any control as to what's in it. And it's possible that there's going to be new evidence that supports the application or things that are raised that the applicant really is going to want to rebut. So what I typically do when someone is in a position of needing a continuance, I'll recommend consideration of a 3-step process. And this process might be, if you're going to take written information only, require that the written information be submitted within 7 days. Anybody can submit the written information. Then after the 7 days, anybody can submit rebuttal to the information that was submitted, just that new information was submitted. And then after that 7 days passes, then the applicant gets to submit final word. So 21-day 3-step process. That's when it's written. Then you have to meet after that to consider that you close the hearing and you deliberate to a decision. The other option is you just do the continuance, come back again, reopen the hearing. But if you're going to reopen the hearing, I would suggest to you that you have made it a declaration at the first hearing as to where you are in the process. We have received all the information that we need, or refer to everyone. We're continuing it for this, the ability for this mandatory, the mandatory continuance. You pretty much have to reopen the hearing. But if it's one where someone has asked, I want to submit a traffic study or something. Okay, if it's by the neighborhood, great, let it come in, then give the applicant whatever time they feel is necessary to rebut that. And sometimes they're going to need to bring in an expert who rebuts that new expert. And by the way, in West Linn, we have a lot of experts here. We have a lot of highly educated, technically knowledgeable people here. So when someone comes in and they submit a traffic analysis, the applicant really needs to provide a professional response to that. That becomes new information, which requires opening that up. So it can get very complex. Have to work within the 120. But be as specific as you can as to where you are when you close the hearing, so that there isn't any debate that, oh, I thought everybody was going to get a chance to speak again. If that wasn't. Additional information. I think I covered that. New information should be required in advance of the next hearing to allow the staff. That's important, that if at all possible, there is an opportunity for the applicants, if the applicant wants to submit new information, try to get that information in so the staff can look at it, so it can be distributed to you, so the public has a chance to look at it and decide whether they want to bring in a competing expert. And the request should be made at the hearing, and the person making the request should be as specific as possible as to what information you would like to see or someone wants to bring in. I think I talked about that. Yeah, evidence. So the important thing about evidence is, as defined by statute, it's facts, documents, data, and other information that's authored to demonstrate compliance or non-compliance. So it can be anything and everything. Then it's up to you to make the determination as to what you find to be credible, and as you weigh it, what outweighs competing evidence. And the rules are not as strict as they are in a court of law. They're administrative hearings, and this is basically the standards of evidence in an administrative hearing, what a reasonable person would rely on when they make decisions. So you have discretion to determine whether evidence should be accepted. And what I mean by that is, somebody comes in and they say, and I want to talk about the 1979 water resource review that was done for this part of the city that affects this historic property. Well, it sounds to me like a 1979 document might be a little aged and might have been updated. So you can either argue with the person about whether or not to accept it at the time that they're speaking, or you can say, let's take it in for consideration now. We'll determine at a later point in the proceedings whether or not to accept it. When you get later on in the hearing, you should make some determination on that. Okay. And substantial evidence has to be based on reliable evidence, and the quantity should be substantial. That's basically what substantial evidence is, and that's what you need to be making your decision on. So, for instance, if you've got a voluminous amount of information that comes in, either opposed to or in support of an application, then you've got a conclusory statement by somebody that says every application that's been made within the city under this regulation has been approved before, and this is just like it. Which one's got more weight? Obviously, the second one doesn't have more weight. It's not backed up by it. So those are obviously extreme examples, but that's the process you need to go through. And let's just follow up on stuff. And on appeal, so when it goes up on appeal, the standard that the reviewing body, the city council, if they were looking at it on the record, or the LUBA in this case, they won't disturb a decision if they look and they make a conclusion that there was adequate information in the record that a reasonable person, a reasonable body would have approved that application. They're not going to make a decision whether they think it's right or wrong, but is there enough in the record? So that's why it's always important to conduct the processes.
Can I ask a question?
Sure.
And it's a specifically planning commission, and it's a specific application. Is that okay to ask? pay them.
Sure. Yeah, we're gonna move on.
No, I just meant just legally.
Yeah.
So,
Wait a minute, now is it pending?
No.
It's not a pending application.
it's been approved.
And it's not on appeal, potentially appeal.
Well, I'm not aware of it being on appeal. But if I should,
appeal, is the appeal period still open?
Which project?
the one on the, Mary,
Ivan Grover's?
no, hers.
It's within the loop appeal period.
Okay, so
So
I
it's-
did
it's
take
around-
nothing.
It's past council, so it's still within the appeal period.
Okay, all right. It's just procedural, but it can like, it's not that important.
Okay. So the last point down there is about the fact that HRB decisions will be reviewed de novo. What did I want to say there? I have to go to my slides so I can see the end of that. Since the council makes the final decision, it's going to make an independent decision. Your record is valuable for them. Ideally, it's not going to be appealed. Most HRB decisions are not appealed to the city council. So we can assume that it's very important that your findings tell the story, because that's the end of the process. But if it is appealed, council gets to fix it.
May I ask what de novo means?
De novo's a new review,
Thank you.
totally new, as opposed to on the record. Just restricted to, we're looking at how the HRB made its decision, not taking evidence. These West Linn years ago, I've been here too long because I get these flashbacks. West Linn used to have a review on the record, restricted to the record, but there was an ability to also introduce new information at that field hearing that was in a very restricted way. It was really, really difficult to work with, and that's why they fell back to it. Admitting evidence, my suggestion is whatever it is, take it in, you get to weigh it. So if somebody submits a petition, I know some communities will say petitions don't mean anything to us. Other communities feel that petitions are representative of such a huge number of people that it's got to be valuable. But you have no idea, you're not going to take the time to validate the signatures. So just take it, don't get into arguments with the community, and then at some point decide whether or not it makes any sense. But again, you're making a decision based on the criteria and the application of facts. So I suggest conditionally accept just about anything without raising a waive, but I already talked about that issues need to be raised locally, otherwise they cannot be used later on appeal. And there's some notice requirements that protect us. And the burden's on us to provide the adequate notice. And if there is a problem, can result in remands, but fortunately there are very many less remands because of this. Findings, these are very difficult to write. John and the rest of the staff do a great job of it. Sometimes they ask us for help. I don't know if we ever really help them better, but we tried. But these essential requirements are that there's some reference to this information in the record that applies facts to the criteria. They're not conclusory statements that say that the applicant submitted everything that was required. That's a conclusion. That's not a finding. Better would be the applicant submitted this piece of information that showed this, that addressed this criteria, which shows that it was met, and then just a whole list of them. And that's significant to explain why you made your decisions. So we'll hold up on it. Okay, and the applicant, sometimes the applicant will ask to prepare findings. That's okay. If your staff is willing to do that, it's just in a draft form. They don't make the final decision. You make the final decision. Sometimes an applicant will have received so much public testimony, they're concerned. They're not sure whether their message on rebuttal was clear. So they may want the opportunity to state it in a more concise manner. And staff might be willing to accept that. Then that comes to you. You then make the final decision. You adopt the final. When it's denied, though, so you go against the staff. Staff made a recommendation to approve. then you don't agree with the staff and you reach a different conclusion, then it's not appropriate for you to say, okay, we just denied the application. We went against staff. Staff, please prepare findings in support of our decision. Because that's difficult for staff to do because they don't believe that. They already expressed themselves. So they're going to push back and they're going to say, we'll help you. We will guide you through a discussion of the issues that you found inadequate within the application, but we really need you to state what those findings are. And that's both for the benefit of you to have your decision stand up and for clarity as to how you made the decision. Staff is not able to read your minds if you haven't expressed it within the record. Doesn't happen very often. There an outline of the evidence that's in the record that you relied on, the decision you made, and we'll try to go through each and every one of the criteria to reach that. And that's all within the final order, which is signed by the chair. How do you do that? Do you bring that back at the next meeting, or it's usually pretty much fine at the HRB meeting of the decisions?
It's pretty much final there, so.
Yeah. But if there is going to be some discussion of change, we want to take the time to stop the meeting to create the finding that you feel is adequate. If you're not comfortable with the finding, you can't say, well, staff, you know what we mean, please write it up.
Let's be clear. It's always hard.
Yeah, if it's really complicated, we can come back to the applicant. Knowing it's gonna be approval, usually grants an extension.
Yeah, that's the proper way to do it.
Yeah.
And I've already talked to him about the 120 days, I'm sure. Okay. So we've got some extra time, I think. Yeah, so
Thanks, Bill.
I think you're welcome. I'd be happy to answer any questions for, I think this covered everything.
I think so.
Okay, good. And you're going to have, or if you haven't already, you're going to have additional information from SHPO, and that's an area, when you guys start talking about these
They
historic.
just changed all their like timing. So it used to be used to submit, if they didn't respond to you in 30 days, then it was kind of, you got a pass. But nowadays they've just been sending me emails and we send over to SHPO that that's not necessarily the case. They can go beyond the 30-day process. And then, so now it's like this weird, I don't know, it's been a strange process. It's been very unclear.
How does it fit into the 120-day period, does it?
I don't know. I will double check on that.
Yeah, I'd be concerned about that.
Yeah,
Because SHPO is a state agency. They have, under Oregon land use law, agencies need to coordinate, so that they can't
Yeah.
have a process that doesn't.
well, we're working to actually get them in the room so we can actually have that conversation and see what our conversation is. And see what's going on there. Maybe tease that out.
Did you just join their listserv? How do you get their info?
We work on a lot of projects, so like all throughout the state. So like when we go and like we're working on a really historic building, we preemptively just do it before we actually do the process. So our first response usually is to look at SHPO when we think something is historic in nature.
Yeah.
Oh, so you go through the process before you file the application?
Yeah.
Oh, okay. That's how we get.
Yeah. So, okay.
We want to see if Michael or James have any.
Yeah, I'll take sorry. Sounds okay. Michael or James, any questions?
Not from me. That was really helpful. Thanks.
Yeah, not for me either. That was good.
Excellent, thank you. So,
Oh, yeah, thank you. It's a lot to take in.
yeah, it's a lot to take in.
Yeah, you're welcome. If you're at all interested in public records, public meetings, we have some materials we've drafted. We can send that to you. That gives a better explanation of ORS 192. When city council members come on board, we give them what we call the our government 101.
Yeah.
There's lots of that's all that stuff.
Yeah.
You guys do a great job doing your meetings and you shouldn't have to worry about that.
And again, as I just say all the time, just if you have questions, just raise them. Right in the middle of the hearing, Bill or someone else from his office will be there. Talk through the issue, so I think that's just the thing.
Yeah, I think the main thing is to make sure the public sees the way the process is going. You're not in conflict with each other and you're not in conflict with the staff and the attorney, but we're all trying to get everything out there, everything on the table, so that everybody has an opportunity to talk about it. And the applicant has a chance to have the final word. All those things, they're gonna be fun. And I'm not, you've never heard me jump in and say, hey, you're doing things all wrong. Never called John after the meeting and said, hey, we need to fix something.
Okay, that's a good item.
Actually, yep.
Items of interest from the board. Do we have any items of interest? That to bring up?
Yeah, I have one. Last month, we talked about getting a site visit at the Westland Paper Company,
Yes.
and I have that secured for the 19th of September. If people can make that,
Be interesting. Yeah.
2 p.m.
Have to check, is it, I guess, there's not really.
That's the same day as our meeting next month.
This is a meeting.
Yeah, if this meeting is going to involve the majority of the commission, you should notice it as public hearing. I mean, a public meeting.
Yeah.
So we provide notice, and then we need to give some specificity as to where people might gather to be there. The new Oregon law talks about there being this opportunity for virtual meetings, but obviously that's not the case of a site visit. But I would be concerned, James probably has obtained the authority to bring you guys on.
Yeah, I
Probably
yeah.
not gonna tell public.
Probably not.
So-
Yeah, he said just very limited, less than 10 people. So
Yeah.
So my recommendation to you would be that if, how many members of the board are there? Seven? I would recommend you not have more than 3.
Okay. Put a process for it.
Is it possible to do 2 separate tours?
Yes, you could.
I mean, I'm not sure the bills are doing that. But
Yeah. But,
yeah, I don't know if he'll be able to do 2 separate tours, but
Okay.
but it's not a public
ma-
meeting that's less than a
It's
quorum.
like, whatever.
But I don't like the idea of trying to have 2 meetings.
I agree.
Yeah.
Yeah.
That's effort to.
Yeah. That's why I asked.
I got a license. I got a license.
Yeah, okay, fair enough. So, yeah.
I've taken the tours. I'd love to do it again, but
Yeah.
if I need to step down, so.
Okay. This is something maybe.
yeah, I guess that's a good question. Who hasn't been through the mill?
I haven't, and I'm super interested.
Yeah, it's cool.
It's really cool.
I bet.
There's some fun stuff.
You're just gonna have to break in after we're done.
Yeah. We'll leave breadcrumbs. Okay.
But is there any potential application that could come?
Yeah. Future, way future.
Well, I mean, the future, so there's the legislative project sort of beginning underway. But that's legislative, so it's the Westland waterfront. But that's a ways out. I
So
mean,
under that process.
yeah,
It'd still be a public meeting.
yes. But in terms of actual applications, the only recent one was a demolition permit last year for Mill A. So that was administrative. It was not a protected structure. It's not listed. So.
And that came through PGE, not the mill, right?
Correct. That came through.
Yeah.
Yeah, I'm just brainstorming here. Okay, but this is something we can follow up on, but September 19th.
Yeah, so it'd be the same day as our normal meeting, but just like 2 p.m.
I mean, nobody really comes to meetings where you should just risk it.
No, people, yeah, it's important to be able to be, careful about this, so.
Can it be considered educational, or, I mean, does everything we do have to be?
If you're forming a quorum, it's a meeting, so.
So wherever that may be.
It sort of interferes with like continuing education. So,
Well, continuing education, different, if something's just for education.
That's what this would be, right?
which is what I went to on Friday in Oregon City, which was
Oh, excellent.
absolutely, it was a great program.
Okay.
Oh, good.
Um,
Glad to hear that.
But anyway, I'm new to this, so I'm just learning the ropes.
Yeah, I think this is a site that could be.
We could.
It would be with a different owner though, wouldn't it?
Still, you gather, you're gaining information. I'd rather have it come under the legislative view and deliver than no. But however that works.
Okay, but so I think maybe we sort of plan for three, no more than three for now, but staff from the city attorney's office will talk a little bit more, and we'll get back to you guys over email. That's okay.
Yeah.
It sounds like we have a month
Okay.
to figure this out, and potentially
Yeah.
another HRB meeting between now and then. No, actually, that'd be the day of the meeting. So, okay, well, we can figure this out. So we'll follow up. If that's okay with you, Karen?
Yeah, so, we don't, there isn't another HRB meeting in between now and then.
Correct. It's the same day.
Yeah, same day, yeah.
Yeah. So yeah. We could meet early, maybe like a week early or something, on the 12th. Or you could pick tonight contingently. So.
Yeah, that was a day that he kind of threw out there that he had some openings, so,
Okay.
So another option is if the limit is 10, and if, let's say, 5 members of the HRB came, as long as you comply with not excluding anyone who came to the site after seeing the notice, there's less than 10 that
As
they
a
allow,
public,
that would be acceptable as a public meeting. Now, you'd have to also keep
Okay.
minutes of the meeting, so
so,
you could do
so
that.
if 15 or 20 people came, we would have to cancel it then.
If 15 or 20 people came, what I would suggest you do is not have a quorum. That if you're identifying that that's happening, then not have a quorum of the HRB members. And, you know, if you still can fit 10 people into the building, as long as all the public members are able to attend. So it's the risk of whether or not you get too many members of the
Yeah.
public.
I think he would cancel at that point, to be honest.
Yeah, well, then you leave it to them, and that would be appropriate to cancel a public meeting.
Yeah, because he doesn't like to have the public in the mill for obvious reasons.
So,
Liability.
yeah, so are you saying then that wouldn't work, that even if the 5 members of the commission came, and then there were a couple of members of the public, would that violate the invitation that they gave you?
As long as if it was under 10, I think he would be okay. If it's over 10, I don't think he would be okay.
Okay, so you could take that, you could try that.
Okay.
if the word gets out.
If the word gets
Yeah,
out,
there's gonna be a ton of people who wanna go.
then you got a problem, then you can't do it.
Can
Yeah.
we go and it's videotaped and then put online? I guess he wouldn't want that either, though.
No, he won't let you videotape either.
No.
Makes sense. I understand.
Yeah, so I think it's some pictures, but
Yeah, it was popular at the time. They're proprietary.
Right.
Yeah, so,
And private, security.
yes, that's it.
Okay, so John, are you gonna send out an email, basically next steps, or how do we want to decide this? Do we have to decide tonight?
Yeah, so we may want to decide on a preliminary level, since you're all in the meeting right now, who the 3 are. If you want to do it if you want to sort of have a base level. And then we can maybe talk about a scenario under like the legislative fact finding
At another time.
at another time.
Okay.
You know, so, James, did he seem open to maybe doing this at a future date if the 19th didn't work? Is this like a one-shot deal or is that something maybe?
Well, he said that the month of October didn't work for him really at all, and then he said that it starts to rain and get real, lots of
Oh,
areas
that's
get
fine.
wet, and he doesn't want people in there, so.
Well, there's gonna be 3 people that are available, I guarantee it, from our group
Yeah,
that day.
Yeah.
So
okay,
I think seems like it makes sense to get the date.
okay.
Should you send an email saying of the group who's
Yeah.
been in it? Because I bet Danny's been in there. Maybe a few other members have been in there. I'm not sure. Like I said, I'm happy. I'd love to go, but I'm happy to step down.
Thanks for setting that up, James.
Yeah.
Oh, let's hope it works.
Yeah.
So I will follow up with an email tomorrow. So
Okay, so we've just decided to keep it on the 3.
if that would be the safest course of
Probably the
action.
safest, yeah.
Yeah,
Because if it's open to the public and a notice gets out there and somebody actually sees it.
Any other
Yeah,
items?
'cause the last time the public had access, there was over 500 people that went through over a weekend.
oh, wow, okay.
Yeah, okay. Any other items of interest from the board?
You went to the training.
I did go to the
Talk a little bit
training.
about that.
Yeah.
Sure. They had people with history or experience in historic preservation from Denver and Nashville and Charlotte, North Carolina.
Wow.
They did a whole session about solar panels from Denver and their experience with it. They had previously not allowed them, but then decided that there was all sorts of reasons to accept them, and they're just sort of temporary additions to the roofs, not harming existing historic structures. They talked about, they did a mock submittal for a historic neighborhood with a new house in Nashville and gave us the whole submittal. And then we formed groups and discussed it.
So interesting.
And then talked about our objections or concerns, and then had to do motions. And then to find out that they had approved it.
Mhm.
You know, it was a really cool modern interpretation of that historic district. Thinking about the Icon project, I just sort of asked,
Mhm.
what if you get a project that seems like it has a lot more going on than the existing historic fabric
Mhm.
in the neighborhood? How do you discuss that as
Mhm.
somebody on the board? And the
Good
woman
question.
from Denver said that they have a ruling on their books that I haven't had a chance to look up yet, which is that any new construction in their historic district has to be a simpler version of their existing
That makes sense.
fabric,
That makes sense.
not more complex with more materials
Mhm.
and more ornateness. And we have a fairly simple historic district, so I could see, I would aspire to something that's simpler or as simple,
Mhm.
just because I admit we have a lot of, we don't have the kind of ornateness that she showed in
Yeah.
our district.
Well, a lot of, very little of ours is original.
Right,
Yeah,
yes, yeah.
yeah.
And I meant to bring like the agenda and the meeting minutes, but I'd be happy to share that.
Just as a staff person. I think
Yes.
it's good. I talked to Shippo about this because I couldn't attend, but I was curious about it.
Yeah.
So we could actually, Wesleyan could actually host a similar
That'd be cool.
thing as well. And so Shippo has said that our CLG grant money can be used for that.
Oh, wow.
In the next round, we can request funds for a similar workshop, but bring people in
Yeah,
and do that, invite members of the public as well as staff or HRB members. So the next round, we can identify that as a goal.
Was there a number of, was it mostly professional people in the industry and things like that that were there or on committees, or were there
There
people
was-
from the public?
there were
They were
3
just
people
curious.
there from the Oregon City Historic Review Board.
Yep.
A couple people from the Clackamas County Historic Review Board, 1 person which overlapped. There were staff liaisons to those historic boards. There was a woman from Gresham And she grew up in northern England in sort of like this industrial area that sort of was neglected and then is slowly being, becoming historic preservation, but not with its original use. And she had a lot of really great comments to say in her role in Gresham. So there were people from all over the region.
That's just curious.
Yeah, it was really great. And when I signed up, they asked a question with the sign up, what are some things you would like? And I specifically said, like, how do you know what to say in the right way during a meeting? And I felt like that last section where they handed us 20 pages of a submittal and had us meet and discuss it, and then showed us the 20-page, also provided the 20-page approval of it, was really interesting. They did a lot about the Department of the Interior regulations and why there are tax credits for rehabilitation, just because there's a lower bar than the other 3 designations. They showed a lot of examples from all over the US. It was really interesting.
Excellent. Oh, I'm glad you heard that. So,
I was so glad people.
Chip will put that on.
what's that?
Chip will actually put that on.
Well, they will help us. Right? I forget who.
Yes, you get that email.
They would help us
I
get
can
funds
follow
to
that.
do that. Remember the sponsor? I don't recall the sponsor.
So yeah, I don't know who sponsored it with
Okay.
Oregon, but
Yeah.
the NA, National Association of Preservation, something out of Virginia Beach, Virginia. Which
Oh, okay.
I'm from Virginia. You don't associate Virginia Beach with
No.
historic preservation.
No.
But anyway.
It's a great place to have that.
organization-
Yeah.
Yeah, that's where they were based out of.
What was it? The National Association of Historic Preservation Commissioners? NAHPC.
Could be.
Okay.
The meeting that I went to, the seminar, was Camp Commissioner
Yeah. Okay. I
Association.
think it was. Okay.
Yeah. And this is a perk. We were told right at the very beginning, by attending that meeting, we get a year membership to their listserv and their boards.
Oh, excellent.
And just, they said it's a wealth of information. Who want to become more educated about the process and what other municipality, how other municipalities deal with items that come up.
Mhm.
So.
Excellent.
Any more items of interest? Items of interest from staff?
I have just a couple announcements. One is that, so I'll start with the less fun one and then with the more interesting one. On August 28th, at 6 p.m. up in council chambers, there's going to be active shooter training for members of boards. So as a staff person, government staff person, I've had this many times. It's given by the police department. It's actually kind of useful information. It's provided in the context of a public meeting. Unfortunately, it's a reality these days. It's rare, but it's just one of those things. So it's free, 6 p.m. on August 28th. So there's that. Second thing is that at the encouragement of our consultant, Kristen Miner, who's working on the National Register nomination for the McLean House, she is proposing to expand the criteria by which it qualifies for the National Register to include criterion D for archaeological. And so based upon prior work in the site, McLean House actually sits, the property actually has all or a portion of a very significant Native American village. And so there's archaeological support. So Kristen reached out to us and she said she's not an archaeologist. She'd like to bring a consultant onto her team to support that part of the application. Talked to SHPO, they said there's funds available for us potentially. So we're in the process of coordinating to increase the CLG grant to cover this additional consultant work. And so that way it can really tell the story of the site as something from sort of pre-contact through contact between Indigenous Native American peoples and Europeans, and then the historical period of the sort of settlement of contemporary settlement of West Linn. So it can really tell a deep story about West Linn potentially. I know that when ODOT was designed in I-205, I understand they actually move some of the actual supports for the bridge to avoid resources. So we think it's a it's a good chance to expand the criterion and whatnot. So, and there's some deeper stories to tell. So we'll keep you posted as that goes on, but just heads up.
Exciting.
Yeah.
Yeah.
So, yeah. So I think at some point we'll probably also reach out to the tribes as well and just sort of, well, I think the first thing is just to make sure we have money to do this, and Chabot has said, yes, that's actually worthy of supporting. So I think, and next month we'll have more updates for you. So,
Can I ask a question?
of course, yeah.
Is there any, it feels like we've had 2 sessions now where we've talked about that rock, the stone, the gravestone.
Yes.
Are we supposed to be doing? Is it on our desk for us to be making decisions or?
It is
anything like
not.
that?
So,
Okay, that's
so,
fine. I just
so,
want to make sure we're not.
so at this point, no, it's not doing
Okay,
it. So, yeah, so at this point, that monument sits on private property on that beach. So I think at this point, we're going to try and connect PGE with the Historical Society, go over this, and it's cool. I believe Jared was going to do that coordination. I just have to follow up on that.
Okay.
And I'll send a follow up on that. But HRB does not have an active act right now. But I think there was talk about having it listed as a local resource, local historic resource for the register there. So.
I one time found this is unrelated, this is
Yeah.
okay, just step back to me, unrelated. I one time found online this sort of a walking tour of our historic district.
Yes.
And I was just thinking, I'd love to have a place where I could just pick up a little booklet from like a little library thing and with a please return.
Yes.
So I could walk around with a little booklet,
Yeah.
learn more about the historic district and then just return it for the next person to use. Cause it's hard to walk around in bright sunshine.
It is.
On the
Yeah.
phone and reading
Yeah.
and navigating a map. I guess that's the kind of thing that maybe I should talk to the Historical Society about. But I just had a thought about that being something that would be nice to.
I believe there is an older handout.
There was talk about those going into some of the little community lending libraries that you see on the street corners in
Oh,
Willamette.
yeah,
That's a
that
good
would be
idea.
great.
Cooperstown used to keep some in there,
Oh, nice.
but I don't know that they still.
Yeah,
The other stores did.
Yeah.
Some of the other stores did too.
nice. It's been on my list
Yep.
to do and I haven't done it yet.
You might contact Jody Carson because I think she's the latest keeper of that.
Okay, great.
Some staff,
Nope, that's it.
you can adjourn.
Okay.
Thank you.
Thanks, everyone. Thank you.
All right, I got a flight in 4 hours, so
Oh,
I'm gonna go to bed.
What did you say?
Got a flight in 4 hours.
Okay, well, thanks for staying up late.
No problem. Pittsburgh's been nice, so yeah.
It's a fun city, so.
Yeah.
Michael, anything else?
No.
Okay. Excellent. Well, thanks, everyone.
Thank you. All right,
Thank you.
bye-bye.
Thanks, guys.